How's it going?
Good morning, Judge. How are you?
Hang in there. I got a sign that says my internet connection is unstable.
Okay.
Can you hear me all right?
Yeah, I can hear you and I can see you.
All right.
How was your weekend?
Go Bucks.
Good morning, Andrew.
Good morning.
Good morning, Katie.
Good morning, Judge.
So, Andrew, I got a question to ask you.
Yes, sir.
So the Bucks are on the Brewers are they've won like 12 out of 13 or something like that. And guess what? The only game they lost was the game that Katie went to. So how do we want to look at that?
Oh my goodness. Yeah, the Bucks woke up. Those first two games against Brooklyn, they were kind of struggling, but
Oh, hey, game two? They just stayed in the locker room. They didn't even bother to come out.
yeah.
Yeah, game two was really bad.
Yeah, but they've the Bucks have definitely woke up. So
Did you see when the guy sprained his ankle?
yeah, Kyrie Irving, yep.
Yeah.
Yep.
Oh my gosh. That brought back some really ugly memories.
Yeah,
The fact that he
definitely
can
with
open up and talk
Kyrie,
after that.
really helped the Bucks.
That's what happens when you get close to Giannis. People get injured. You're just standing next to the guy.
Yeah. So Andrew, after this, we do need to talk to you about another issue.
Okay.
That's unrelated to this one.
Yes.
Right. Okay. Yep.
Okay.
Mr. Orange, is Milwaukee pretty happy right now?
We are. Brewers are on a winning streak and avoided a bullet with the Bucks. Starting 0-2 put everybody on edge. So, yeah, everyone's really excited now.
So as I was telling Mr. Adams, what are the Brewers, like 13-1?
Over the last stretch, yes.
So the only game that they lost, Katie was at. Well, what should we do about that? Should we sanction it?
Just keep her away.
And I can't believe it, I mean, I know Katie, and she doesn't get down to Milwaukee very often. It's not a thing, So she goes down and she has the opportunity to go to the game, which I would do too, And it's like a once in a year, if that. And I get to the game and they lose, and it's the only game out of 14 games they lost. Like, oh my God.
Then I should have went and watched the Bucks too.
Yeah, well, you need to stay away from the Bucks. If you could.
Over the course of about 7 years, I got to see the Brewers about 5 times, and they were 0-4. I got to see them play when Jose Canseco stole his 40th base, and he was playing for Oakland at the time. He had a 40-40 year that year. I saw him steal his 40th base.
It's still there.
I didn't think I'd ever get to watch them win a game. I got to see them in Minnesota, and they won that game. So,
That was a while ago that Canseco was stumbling. It was a long time ago that he was playing, and even longer time ago that he was stealing bases. That's for sure.
yeah. I even got to see Joe Morgan play that. He was playing for Oakland at the time, towards the end of his career.
Mm-hmm.
So that's how long ago that is. So do we have everybody?
We did have Lawrence, it looks like, did he leave and come back? Or is coming back?
Good morning, Art. For the record, Kurt Bale on behalf of Mr. Larsen. I just spoke with him. I've been on the phone with him pretty much most of the morning. He said he got whatever technical issues resolved, and I would assume to see him any moment now.
Okay, we're waiting for him. Morning, Ashley.
Morning.
Morning, Leah.
Morning, Judge.
So Mr. Oranger,
Yes, Judge.
the Brewers playing today?
They do. 7:10 p.m. At home against Cincinnati.
All right. Right, cool.
I think they have a long stretch with very few off days right now. So that's why, making sure the starting pitching goes as deep as it can is important. And they've got that's what's so great about them is they can hold on to leads if they can get a lead because they've got such good pitching at the back end.
It's fun to be a Wisconsin fan right now in the sports. Mr. Bull, Mr. Bull, any word from your client?
I just spoke with him. Apparently, because he's logged into Google, it's just showing his Google image on the screen. So he's working on logging out of Google and logging back into Zoom.
Okay. Mr. Larson, can you hear me? We can see you. Really?
Can you hear me?
We can see you too. Right.
You can hear me too?
Yep, I can hear you too.
Perfect.
Right.
Let me turn this light off.
Read the case, please. And that was completely echoing for me, so I think what needs to occur here is you're not speaking, you need to mute yourself. Mr. Larson, can you mute yourself?
Are you talking to me?
Yes, Mr. Larson.
I can hear you.
Can you mute yourself?
I can't hear you. One more time.
Can you mute yourself?
Mute myself? Yes.
Thank you. Okay, can you read the case again, please?
The case today is in the interest of the St. Croix Chippewa Indians of Wisconsin versus Lawrence Larsen. Case number 20-CB-204. Presiding today is the Honorable Judge Stephen Woolley. The appearances for the record, Your Honor, are for the tribe, Andrew Adams, Ashley Duffy, and Leah Jers, and the defendant, Lawrence Larsen, with attorneys Andrew Odinger and Kurt Ball.
Okay, good morning, everybody. Today, we're having a motions hearing and a pretrial. So today, the first thing I had informed the parties that we would do, first thing this morning, would do the motions hearing. With that, Mr. Odinger, I'd ask you to explain to the court. I know you filed a motion and you supported the brief, but I still want you to explain to the court what your motion is and your basis of your motion. I'll give the tribe an opportunity to respond and we'll go from there. Mr.
Thank you
Odinger?
very much. Thank you, Your Honor. And for the record, we did confer, Attorney Adams and his colleagues and I did confer prior to the hearing today, and we can let you know what we discussed. I have not heard back yet from Mr. Adams as to whether he agreed to some items we discussed last week. I know it was a busy weekend, but Attorney Adams can speak to that. But we did confer last week to see if we could reach an agreement on these issues. This motion that's before the court is a motion that Lawrence Larsen filed back on March 31st is when we filed our opening motion. And the authority for the motion is contained exclusively in the tribal court code. And that's section 327D, which characterizes a party's refusal to provide requested information as contempt of court. That is, a party is violating the court's order. And second, section 331 of the tribal court code authorizes the court to order payment to one party by the other for a failure to comply with discovery obligations. So those are the bases for filing the motion that we filed back in March. And I'll elaborate a little bit further, of course. But as we detailed in the submission that we sent to you, the tribe withheld documents from Lawrence and from the court. Documents that Lawrence had a right to see, a right to review, and a right to examine prior to filing its motion for summary judgment and prior to trial. And the reason that the tribe has not explained the reason why it's withheld information, but it's very important for the court to understand that the tribe has admitted that it withheld documents. In its submissions to the court, the tribe admitted that information was not provided. It gives a couple of excuses and it gives some reasons why, but it is not disputed that the tribe withheld information from Lawrence. There's a couple of categories of information that our motion pertains to. but they all relate to information that Lawrence asked for that the tribe was supposed to have given him. Under the court scheduling order that was entered about a year ago, the tribe was supposed to respond to Lawrence's discovery requests on or before August 25th, 2020. Lawrence sent a list of questions to the tribe, and the tribe was supposed to provide its responses on or before August 25th, 2020. And among the things that Lawrence asked for were communications to and from the NIGC, communications that referenced Mr. Larsen. And those are critical because the tribe in this case has admitted that it didn't conduct its own investigation into Lawrence. To the contrary, the tribe just relied on what the NIGC told the tribe about Lawrence. But the NIGC never investigated Lawrence either. So there's a big gap of information and misunderstanding as to what Lawrence's role actually was. In addition, Lawrence asked the tribe to produce any communications from Chairperson Lowe, Susan Lowe, to and from the NIGC, and her communications that talked about Mr. Larsen, again, because they're relevant to the case. The tribe didn't do it. Initially, the tribe didn't provide any of that information. Now, to be clear, the tribe did produce some information, but it never provided all that it was supposed to provide. So Lawrence, through counsel and at significant expense, both to Lawrence and to the tribe, had to send repeated demands for more information, sending letters that are before the court that say, look, you can't possibly have given us everything. Please look again. Please look again. Please look again. On 4 or 5 separate occasions, we had to do that, none of which we should have had to have done. Finally, as we reached the spring, the tribe said that it had now provided everything. And so we proceeded to take some depositions, specifically the deposition of Susan Lowe. And during that deposition, Susan Lowe lied. She lied because she testified under oath that she never used her personal email address to conduct tribe-related business. She said that under oath, and the transcript is before the court. It turns out that that wasn't true. And the only reason we know it wasn't true was because Lawrence, not trusting that the tribe had done what it was supposed to do and be truthful, sent a Freedom of Information Act request to the NIGC to get some, but not all information, where it was revealed that Ms. Lowe was using a private email account to correspond with the NIGC. After Susan Lowe's deposition, the tribe admitted that it did not search her email, that it did not produce her email, and that it did not collect that email. The tribe admitted it. And if I'm saying anything untrue, you can ask Mr. Adams because he confirmed it in his letter to me. The excuse that the tribe gave was that counsel for the tribe didn't think, had no reason to believe that Susan Lowe had used her personal email, so they didn't search it. But they then eventually did search it, and they produced a few emails. They produced 13 emails, or 13 pages of emails from Susan Lowe. But they produced those 13 pages on March 31st, 2020, the same day we filed our motion to compel. And that date is very important because that date is the date that discovery closed, which meant that we couldn't do anything with that email that was produced. We didn't have an opportunity to ask Ms. Lowe about it because we didn't have the emails until after the deposition. We couldn't ask the NIGC about it because discovery was closed. We couldn't conduct additional depositions because discovery was closed. So in other words, the tribe waited until 4:30 p.m. on the day that discovery closed to finally give us a few of the documents that we had been asking for over 1 year. And that constitutes a violation of the tribal code. It violates fundamental basic precepts of fairness because Lawrence has a right to put together a defense. And the information that continues to be withheld is central to his defense. Now, one last item I want to talk on that is quite important concerns emails. The court heard last week and in the submissions from the tribe, a lot of references to the fact that the tribe produced 55,000 emails. The court said it, Attorney Adams said it, they said it in their submissions, that 55,000 emails were produced by the tribe. For the tribe to continue to tell the court that it produced 55,000 emails, which is true, it did, not right away, but eventually it did. Every time the tribe relies upon the statement that it produced 55,000 emails, it's misleading the court. And it is so disingenuous to say that the production of 55,000 emails means anything. Why is that? Because none of the Susan Lowe emails were contained in the 55,000 emails. No emails concerning the NIGC's investigation were contained in the 55,000 emails. None of the documents that we got from the NIGC that assisted Lawrence's defense were contained in the 55,000 emails. None of that information was contained in the 55,000 emails. Now, if the court would like, and if Attorney Adams would allow me the opportunity to share my screen, I can show some examples as to what was contained in the 55,000 emails. Attorney Adams, may you enable me to share my screen?
I just did that.
Thank you. $55,000 emails were produced, Judge, and the tribe constantly refers to that. What was in that, what was produced? This is a very long report about the migratory bird seasons and the environmental impact that it had on tribal hunting. That's something the tribe produced in response to our requests. It produced every single calendar entry for a 4-year time period that talks about, well, everything that the judge sees that's on the screen. That's included in the 55,000 emails that was produced. When there was free bingo and when deer hunting began. The 1,000 emails of the 55,000 emails that were produced were emails from Facebook to Crystal Peterson that reminded her about birthdays and if people wanted to answer friend requests to her. Included in the 55,000 emails is a report of every accident that ever happened pursuant to the tribe's insurance policy in 2019. And remember, Your Honor, Mr. Larsen had nothing to do with the tribe anytime after 2018. The 55,000 emails included EPA's drinking water standards and health advisory tables. The 55,000 emails included a gas station development traffic study. The 55,000 emails included a final report on the juvenile justice system planning. It included a franchise disclosure to see if a Steak and Shape would be operated by the tribe. It included operator training so that people would know how to service underground propane tanks. Your Honor, they included a Mendona Restaurant Group presentation, and these are all hundreds of pages long. That's what's included in the 55,000 emails, Your Honor. That's what they dumped on us. And none of it included the critical information concerning Ms. Lowe. And yet, despite dumping so much information on us, very little of which was relevant, the tribe keeps telling you, Judge, we gave them 55,000 emails. It's misleading you, Your Honor, just like it tried to mislead us. So every time you hear the tribe refer to 55,000 emails like it does in its submission, all it's doing is misleading you. So I absolutely acknowledge, as I always have, that the tribe produced 55,000 emails that had absolutely nothing to do with what was before the court and what is before the court. And worse, it has admitted that not included in those 55,000 emails was the information that was most important to us, that it did not disclose until March 31st, after discovery was closing. That's improper, Your Honor. So what are we going to do about it? Well, we filed a motion to compel and a motion for sanctions. The court has the authority to send a message to the tribe that it can't abuse process like this. At this point, everything that happens in this case is tainted unless we rectify the fact that this information was kept from Mr. Larsen. So in our motion, we asked for a couple of different pieces of relief. First and foremost, we asked that the court order the dismissal of this case. That is well within the discretion of the court. It's supported by Wisconsin and federal case law because this is an egregious violation of discovery rules. And the fact that the tribe misled the court by making reference to these 55,000 emails while not admitting and not acknowledging the fact that the most critical information was withheld, that's a huge problem. Lawrence Larsen has a right to a defense. The tribe has the burden of proof, and it cannot hide the ball. It cannot hide the ball from the court or from Mr. Larsen. To do so taints every piece of this proceeding going forward. So we're asking for dismissal of the case with prejudice as a sanction for the misconduct of the tribe. Number two, Mr. Larsen is asking the court to rely upon the authority given in it in Section 331, which authorizes the court to order payment to compensate a person for a loss suffered as a result of contempt of court. And remember, as I described earlier, the tribal court code says that failure to provide a record, document, or other object requested is contempt of court. The tribe admitted that it failed to do it, Your Honor. Now, the tribe says, well, we did it at the very last minute, but they acknowledged that they didn't do it when they were supposed to. So the second piece of relief we're asking for is an order of attorney's fees relating to us having to deal with this issue. And we can submit an itemization of the court for those costs. The third piece of relief that we're requesting, Your Honor, concerns Ms. Lowe and her emails. We know that even though the tribe gave us a handful of documents, that they did not give everything. They still have not given everything, and we have a right to it. The reason we know we don't have everything is because we have some information from the NIGC, so we can cross-check it against what Ms. Lowe and the tribe eventually produced. We know there's information missing, information concerning Mr. Larsen, so it's critical that we have it. So the third thing that we're asking for, Your Honor, is that the court order or the parties agree that a third party analyze Ms. Lowe's email to pull out anything that could be relevant. And Attorney Adams and I discussed this last week, where I said, I'm happy to agree upon any suggestion as to who it is that does that, as long as it's somebody with the proper certifications. And when they pull that information out, Attorney Adams and I can review it to see what information is relevant, and we can then have the benefit of what should have been given before. So that's item 3 that we're asking for, to have a third party take a look and see just how egregious and what else hasn't been produced, how egregious the tribe's withholding of documents is. The fourth item we're asking for, Your Honor, is that we have an opportunity to conduct additional discovery of Ms. Lowe after we get these documents, because the tribe deprived us of the opportunity to ask her questions about these critical emails because it didn't give us those emails until after her deposition. So part 1 is getting the emails so that we can review them, and then part 2 is asking her about them. And in particular, I'm interested in knowing why she told me under oath that she never used her email for personal purposes. She never used her personal email for tribal business, when in fact she did. It's been demonstrated that she did. And finally, Your Honor, the last piece of relief that we're asking for that relates to most of these other pieces is we're asking for an adjournment of the trial date, because it's right now scheduled to take place only a week from now. We need an opportunity to do this additional discovery if the case is not dismissed. We need an opportunity to conduct this additional discovery, get the emails, ask Ms. Lowe and potentially others about them, so that we can get to the bottom of the true facts in this case, which Mr. Larsen is entitled to know under the rules. And number 2, figuring out just exactly how and why the tribe did this. The tribe set forth in its submissions to the court rationales and excuses as to why the email was withheld. And what was told to the court under oath through the affidavits of Ms. Duffy and through counsel were that they were led to believe Ms. Lowe didn't use her personal email for tribal business. Well, we need to figure out exactly how this occurred. Was it a conspiracy amongst a lot of people to withhold this information? Was it truly just an oversight? We have a right to know, and we want to make sure these people are held accountable, because Mr. Larsen has incurred so much expense dealing with something that he was entitled to, that he is going to seek redress for the fact that he had to suffer through it. So we need that additional discovery. So again, Your Honor, it's a long list, but it's a very serious issue where we're asking for dismissal, we're asking for an award of attorney's fees, and if the court is not inclined to grant that, At the very least, we are entitled to the additional discovery of the emails, all of the emails that were withheld, of a right to take additional discovery and deposition of Ms. Lowe, and of an adjournment of the trial date so that we can get this done so that Mr. Larsen doesn't have to go into the hearing blind, which is what the tribe's been trying to do. And with that, Your Honor, if you have any questions, I'm happy to answer them. But those are the theories of relief that we're asking for.
No, thank you. I have no questions. Mr. Adams?
Thank you, Your Honor. Well, to start off with, Your Honor, I would respectfully disagree and posit to the court that the tribe has complied with all discovery requests received in the case prior to the last day of discovery. And yes, Your Honor, it's a true statement that I made to the court previously, and I'll continue to make, that the tribe did provide over 50,000 pages of documents to the defendant per his requests, per Mr. Larsen's specific requests and his counsel. And the tribe asked the defendant to limit those requests prior to the major email, document production, and the defendant and his counsel refused. The relevancy of the additional discoveries that is sought by the defendant, the forensic email examinations and the depositions of attorneys does not outweigh the considerable burden it would place on the tribe, Your Honor. And quite like frankly and clearly, Your Honor, the tribe hasn't engaged in any discovery behavior that's worthy of sanctions. We preserved the tribe did preserve, and it did have access to emails that were sent to and from tribal addresses. It did not unduly withhold or fail to preserve any relevant emails, Your Honor. The tribe also did not purposely fail to produce the tribe's settlement agreement with the NIGC, and the defendant ultimately received both the settlement agreement and the emails between the NIGC and the tribe's lawyers that were leading up to the settlement agreement. Additionally, Your Honor, the tribe provided the defendant with the backs of the disbursement checks that he received on March 24th after the tribe's lawyers obtained access to them on March 19th of 2021. Your Honor, the defendant was not harmed by this late disclosure because it was still within the time period set for discovery. Your Honor, I don't, just from a common sense standpoint, I don't understand how the defendant and his counsel keep saying that we violated rules that were set forth in terms of discovery. Your Honor, we provided the documents before the discovery deadline that was set in the scheduling order. Your Honor, when it comes to the 50,000 or the 55,000, pages of documents, most of these documents are email communications specifically requested by the defendant. The tribe requested that we limit, or the defendant limit, the request to reduce that number of documents, and the defendant refused, Your Honor. So in terms of the tribe fulfilling its obligations under the St. Croix Tribal Court Code, because the defendant didn't limit the scope of that document request, we were obligated to provide all of those documents, including the documents that counsel for the defendant just walked you through in terms of the EPA and the Fish and Wildlife Service, reports and the emails to Crystal Peterson. Your Honor, we were obligated to provide those under the rules, which we did, and they were within the parameters that were set by the defendant. And one of the reasons, Your Honor, that number was so large is because we did provide all of the relevant and non-privileged documents that the defendant sought. The defendant received the requested information from Chairperson Lowe's personal email account on March 31st, 2021. I'm not going to refute that, Your Honor. It was the day that discovery concluded. But the tribe's attorneys were not aware that Chairperson Lowe was using her personal email accounts for official business until her deposition on March 16th. And from that day, the tribe's attorneys began working with Chairperson Lowe to obtain the requested emails. The defendant received non-privileged relevant documents involving its former attorney, Jeffrey Cormell. The tribe provided the defendant with a privilege log of emails. It did not produce under a claim of privilege, Your Honor. The privilege log included a list of 554 emails and documents. Each email contains the sender, the recipient, the subject line, and it enabled the defendant or gave the defendant a general description of the documents withheld. Your Honor, the defendant chose specifically not to subpoena Attorney Cormell to take a deposition. But despite that fact, we provided documents that were produced by him. I'm sorry, not produced, but documents that were associated with him that fell outside of any type of privilege that would attach to those. Your Honor, we would urge vehemently that dismissal of the case is not warranted in this type of situation. Your Honor, at most, the court should reopen discovery, push the trial back, and allow Attorney Ottinger and his client to potentially depose Chairperson Lowe again. But Your Honor, this case should not be dismissed based on the arguments that Attorney Ottinger is making on behalf of his counsel. And Your Honor, you know, I would also argue that discovery shouldn't be reopened because the non-established relevancy of the information sought doesn't outweigh the considerable burden it would place on the tribe. Your Honor, we do not believe that there's any relevant information that can be obtained from a deposition of the tribe's attorneys. And the defendant had the opportunity to take the deposition of a number of other potential witnesses and chose not to. So, Your Honor, respectfully, I will continue to argue that the tribe met the discovery deadlines that were set by your order. We have not withheld any information from the court because from a discovery standpoint, we haven't shared documents with the court. Your Honor, the documents that Attorney Ottinger received that were contemporaneous to Chairperson Lowe's deposition were received months before the trial was set to occur and before the end of discovery. So, Your Honor, additionally, the tribe produced 10 different sets of document productions. over the course of the discovery of the scheduling order. It wasn't in one fell swoop. There were times where we discovered additional documents that were relevant to Mr. Larsen's defense, and we provided those over 10 different occurrences. Your Honor, quite frankly, Mr. Larsen and his counsel asked for everything related to the tribe's businesses and the tribe's economic development corporation. And so it makes all the sense in the world that without any specific limitations upon time frame and individuals, that it would include emails about a steak and shake or emails about some restaurant that had nothing to do with Mr. Larsen if he's asking for everything related to the tribe's businesses and economic development corporation. So, Your Honor, we will, the tribe does not disagree with when the defendant says that a large number of those emails potentially were not relevant to his defense, but he specifically asked for those and he did not limit his request. So, Your Honor, we in that situation are essentially in a catch-22. We've got to provide a lot of documents that may not be specifically relevant to Mr. Larsen's defense, but he specifically asked for them and he didn't limit his request. So with that, Your Honor, again, the tribe respectfully argues that we did not commit any discovery abuses that rise to the level of dismissing this case with prejudice. We also did not commit any discovery abuses that rise to the level for any type of sanctions against any of the attorneys or for attorneys' fees. And with that, Your Honor, we request that the case move forward and the court have an opportunity to conduct a trial so that it can the court can hear for itself the merits of the case, the facts of the case, so that the court can apply the law and we can get to the outcome of some type of judgment and order that I believe all of the parties are looking forward to. Thank you, Your Honor.
Thank you. All right, you both have talked about Susan Rowe. There was a thought that, as the tribe explained, that they were under the impression that Susan Rowe was not using her private emails to her private phone for tribal business until late in the discovery process. So they did provide the information on the last day of this discovery. I'm not convinced at this particular point in time that dismissal of this matter based on the information that you just argued to me is warranted. So I'm going to reserve judgment on that, though, because I do want to find out what Susan Rowe provided and did not provide. Mr. Ottinger is indicating that he can prove and demonstrate that through his communication with NIJC or NIGC that there were other emails between Chairman Rowe and them. The value of that is to be determined by them, and I agree with that. That falls within the discovery request. I really like the idea of a third party doing this. That way, that has, yeah, I like that idea. So let's make it that way. How long will that take?
Your Honor, assuming that Attorney Adams and I can reach an agreement on who does it, I don't think it takes long. Once we find somebody and can agree upon somebody, I've done it in other cases. It can usually be done, within a matter of a week. What I don't know is how much there's going to be to review, because what Attorney Adams and I anticipate happening, and Andrew, correct me if I'm wrong, but what we discussed is that they would generate a report that said, here's a list of everything I found. And then Attorney Adams and I would look at it to see what should we pull out and what should we not pull out, to make sure we're not interested in anything irrelevant. Because it could be hundreds of thousands, because it could be a handful. We don't know that. So I don't know how long that part of this process will take. But I can endeavor to work as quickly as possible so that we can continue to move forward. But I don't want to commit to a time frame until we know exactly how much of a volume we're talking about there is.
Yeah, Your Honor. I mean, I wouldn't disagree with that. I mean, I believe that the initial search could be done, relatively quickly. I think where it could take some time is I would anticipate that, like, the e-discovery expert would create a spreadsheet that essentially would detail the emails, and then Attorney Ottinger and I would need to have a conversation then at that point about any type of, like, potential privilege that may attach to emails. So the search wouldn't take all that much time, but I believe it would take some time for us to review the initial search results, and then I think it would have to essentially be taken in stages, that initial search and then a subsequent kind of production based on a review of the initial search, if that makes sense.
It does make sense. All right. So if it isn't apparent, I'm going to make it clear. We are now postponing the trial. We're not having the trial next week. I want you guys to get together and agree on who's going to do this review. And again, we're talking about of the evidence that anything in Susan Lowe's private correspondence with the National Indian Gaming Commission, and that's what we're talking about here.
Your Honor, I would suggest that be modified a little bit, only that what we requested and what we believe exists is communications between Ms. Lowe and the NIGC, as well as communications from Ms. Lowe about Mr. Larsen, because she has sent emails. The tribe did produce some of them on March 31st, but it additionally should correspond to communications concerning Mr. Larsen, because and her knowledge of the work that he did and how it benefited the tribe. I would request that also be included in what we are able to obtain.
Mr. Adams?
Your Honor, I mean, so to understand it correctly, Attorney Ottinger is asking for, any communications with the NIGC, but also any communications that mention Mr. Larsen to any other third party. Is that what I'm understanding?
That's what I'm hearing.
That's correct. Anything that's not privileged, we wouldn't be seeking
Yeah,
anything privileged.
Your Honor, I'm not gonna. I don't have a basis to object to that. I mean, if there's no privilege that attaches to a communication like that, then I believe it's fair game in this situation.
Okay, and again, that's on the private, Susan Lowe's private emails.
Yes, Your Honor.
All right, So any, Susan Lowe's, and is there a time frame for that? From when to when?
Yes, Your Honor. It would be from, just pull my materials out here. We included it in the request that we sent to the tribe last year. It would be the time period immediately before Mr. Larsen's engagement with the tribe through the entry into the settlement agreement with the NIGC. I don't have that document in front of me right now, but it's the date period that we included in our requests that the tribe should have responded to last August with this information. So it's approximately 2015 through 2021.
And your request is exclusive to Susan Lowe.
It initially was too many others. It's just that at this point, we know that that the tribe, in connection with Susan Lowe, did not even think to check for this documentation. We don't know what else has been withheld or has not been searched for. We just caught an instance here of Miss Lowe. There may be others. We just don't have direct evidence of it like we do with Miss Lowe.
Mr. Adams, give me the dates.
Your Honor, I believe Mr. Larsen was initially entered into a relationship with the tribe in 2015. I could be mistaken there. And I believe, the settlement agreement was signed in, I believe it was 2019. So, if you just bear with me for a second, I'll try to come up with the specific dates.
Your Honor and Andrew, I brought up the requests, and the time period in our requests was January 1st, 2015 is when they began. And yeah, I believe that the settlement agreement was finalized in September. So I think that you're right, Andrew. And I think that you and I can agree on it. That's the time period. We can fill in the dates, but it's from that 2015 through the settlement agreement.
Okay. Susan Lowe's emails that she used for business are on her private phone are open to discovery. Mr. Adams and Mr. Aldinger are to come up with the person who's going to do this. I'm going to look for you guys to give me a schedule, some kind of time frame that you think it's going to take. I understand it's in stages, so let me know, let the court know when you think the person's going to complete the review. After you guys have both haven't had an opportunity to look at what's being presented, how long you think you're going to need to do to review it before you can be ready to bring it to court. And then after you've done that, then you guys are going to get back to the court. And we will schedule, put on the calendar the date that we're going to come back and rediscuss this. So at that particular point in time is the time that we'll discuss whether there's a need for further discovery, or whether there's a need for further deposition. Right now, if there's any kind of, I'll put on the record that if there's any kind of substantial discovery of things that Ms. Lowe has not provided to the tribe, or the tribe has not provided to the defendant, the court will then probably grant the additional time for discovery. But when we come back to court, is when you're going to tell me if I'm looking at granting discovery, how much time you're going to need for that, if we need to do that at all. Okay, is there any questions about this?
Yeah, just a clarification question, Your Honor. So, am I hearing it correctly that you're gonna essentially, like hold another, like essentially something to akin to a status conference, say, at some point in the future to take up the issue of additional discovery?
Yes.
Okay. Do you have like a time frame in mind? I mean, would it be helpful to set a status conference now so we know when, we need to check in with the court to provide an update as to the email like search that the independent third party is going to conduct?
I'm gonna let you and Mr. Odinger come up with that.
Okay.
Here's what I envision occurring. You guys are gonna come up with together and come up with a person, our agency or department or someone who's gonna do this. You guys after that, after you get that a person appointed, you're gonna have an idea of how long it's gonna take for that to occur. Then that's gonna occur, and you're saying that can happen in as short as a week. And after you get the information that they put on the table, you guys are going to look at it and you guys are going to consult about it. And at that particular point in time, you're going to come up with an idea how long it's going to take to review. That's when you guys are going to get back with me. We're going to do a phone conference and we're going to set up the next hearing date. That's when we'll set the next hearing date, which will be essentially the status conference. And at the status conference, as you referred to with Mr. Adams, is when we'll decide whether we need to do further discovery or not. If the one possible outcome is there's nothing significant been withheld from the defendant, we schedule the trial. We don't even need to go to any further discovery. But on the other hand, there are significant documents that have been withheld that where the defendant requires more time to investigate, needs to talk to Susan Lowe. We didn't schedule another deposition. We schedule a more down the line, depending on what you find in those private communications that Ms. Lowe has had with the National Indian Gaming Commission and about Mr. Larsen. So is that clear?
Yes, Your Honor. I mean, yeah, Attorney Ottinger and I can confer and then report back to the court. I was just curious if it would just be helpful to just set a status conference now so that we know the parameters of when you want to hear back from us and we can be prepared to, report back to the court. But I mean, I'm definitely fine with moving forward with just the conferral and then us reporting back to the court as soon as we can.
Yeah, that's why I think I want to do it that way. Yeah. I'm expecting to hear from you guys within 2 weeks, though. I mean, it may take longer, and you can let Katie know if it's going to take longer, but I'm expecting to hear something from you guys in 2 weeks.
Yes, Your Honor.
Then for sure, within a month, we need to get together and I'm not holding you to this, but we need to get together and reschedule when the next formal hearing of whatever it's going to be, whether it's going to be a status conference or whether we're going to just schedule a trial. We're going to do that within a month.
Okay, and
I'm not going to pin you guys down to a date right now. We'll leave it to you guys to work that part of it.
okay, and I just wanted to bring to the court's attention, Your Honor, that roughly for like the first 2 weeks of July, I've got some ceremonial obligations that I need to meet at my ceremonial grounds in Oklahoma. So I believe Attorney Ottinger and I can definitely confer between now and the end of the month when I effectively, have to attend ceremonies in Oklahoma. But I believe Attorney Ottinger and I can definitely make strides towards definitely identifying a third-party technician and then getting that initial, search completed. I just wanted to bring to the court's attention that it'll be difficult for me to do it, not impossible, but difficult for me to do a status conference like during those first 2 weeks of July, just because of, needing to attend ceremonies in Oklahoma. But I will do everything I can, Your Honor, to meet any deadlines that are imposed by the court.
Well, however, and again, there's a couple of things that need to occur. First of all, you need to find a person who's going to be able to do this. And you need to agree on that person. So that's going to take something. And you need that person who's going to have to make their schedule and get this stuff together. But if for some reason a date comes up that we're in that 2-week period, you have individuals who work with you who are able to address these issues also. Or you can communicate with them and they can appear on behalf of the tribe and they can speak on their behalf. Just as Mr. Ottinger has, he has a sort of a co-counsel on his side. I haven't heard much from him, but he's there. So if there's something needed to come up and you needed someone to fill in, he also has backup. So we can cover that. But we'll try to accommodate your schedule. So I recognize also the importance of that to you. So, and I would accommodate your schedule as best we can. But given the date where we are right now, I don't see this as going to be an issue actually.
Okay, thank you, Your Honor.
Anything else?
Your Honor, just to note, so we're clear that the court is reserving making a ruling on the request for dismissal and for sanctions pending what is ordering here.
Yeah, that's true. It depends on the extent of what's in the private emails. Although, oh yeah, we'll leave it at that. We'll leave it at that. Okay. So, my order today is that we're going to postpone the trial and that'll set for a date in the future to be determined. Tribe and the defendant are going to get together and they're going to appoint an individual who's going to examine Miss Susan Lowell's private emails to review the private emails that she's had with the National Indian Gaming Commission and the private emails that she has generated regarding Mr. Larsen. And the time period we're looking at is from January 1st, 2015 to I have August 24th, 2019 as the date that the National Indian Gaming Commission issued the report. So it'll be within those timeframes. And then after that report has been generated, the tribe and the defendant attorneys are to get together and see how much time they need to review the documents before we go forward. And then we will get together with me for a phone conference and we'll set the next hearing, whether it be a review hearing or it's going to be the trial. And again, as I spelled out earlier, what I'm talking about is if the discovered information is not of any significance, we'll move to the trial. If the discovered information is significant, the new information that's on Susan Lowe's private emails. If it is significant, we will then set a discovery time, and we'll move on from there. If necessary, we'll schedule a status conference and discuss the parameters of how we're going to look going forward. Keep it in mind, Mr. Adams has indicated to the court that the first 2 weeks in July are going to be difficult for him to have any formal hearings, and we'll try to accommodate that schedule. Right now, from where we are right now, we're 2 weeks into June. I don't see this getting done within a month, so I'm thinking we'll have any problems there. However, if it does turn out that we are able to move forward before that time period, Mr. Adams does have co-counsels that can step in for him. Okay, any questions on that?
Not for me, Your Honor. Thank you very much.
Mr. Adams?
No, Your Honor. Thank you.
Okay, you guys. So one last comment, in case you guys don't remember, it's still spring. Court's adjourned. We'll talk to you guys soon. Once you guys have made your